Welcome, everyone. Thank you so much for joining us tonight. We're really, really happy that you're here with us discussing something that's obviously very important. My name is Avery Horn. I work for Assemblymember Anthony Rendon in Assembly District 63, and we're partnering tonight with Assemblymember Christina Garcia, and you'll hear from them both tonight before we begin our presentation. But before that, we are going to get some introductions here. So we'll transition into those right now. So I would first like to introduce Assemblymember Anthony Rendon.
Thanks, Avery. I'm happy that everyone is here today. I'm especially pleased to be co-hosting this event with Assemblymember Christina Garcia. Christina is not only my colleague, we both got elected in 2012, but she's also my neighbor. She represents the district adjacent to mine. What I always say about elected officials is that it's easy to say all the right things in front of a crowd. It's easy to say all the right things on a microphone in a public setting. You get to understand what somebody is really about when you have private conversations with them. I had a conversation with Assemblymember Garcia about this very issue, the very issue we're going to talk about. Children with special needs and the need to make sure that children with special needs have the services they need. She and I had a conversation about this very, very recently. It's something that is so central to her values and so important to her, but also important to us in the Assembly. So I'm glad to be co-hosting this with her. The other thing that we have in common is that we also have a tremendous experience in education. Both Christina and I come from education backgrounds. What I learned from my own years in early childhood education is that every child deserves the best education possible. And that isn't any different for children who have special needs. That's just the way I feel. And it's also the law in this country. And that's why we put together this program tonight to help you understand how to get the services your child needs and deserves. Robert Borelli of Disability Rights California will be taking you through what you should know. So I want to thank Robert and thank the Disability Rights California, not just for being here today, but for all the work they do on behalf of California students and people with disabilities. Now, let me just remind you about what Avery said earlier. If you have questions during the presentation, you can email them to my email address, and we will try to get everyone's questions answered at the end. The email address is assemblymember.rendon@assembly.ca.gov. Thank you again. I hope you get a lot of value out of this program. Avery?
Thank you so much, Mr. Speaker. Next, we're going to welcome Assemblymember Christina Garcia, who's also going to say a few words.
Thank you, I appreciate it. And thank you everyone who's joined us today. I want to thank the speaker for working on this. His team has been working hard, and the advocates for coming online to answer questions. I'm going to keep it brief. I think the speaker made some great comments. We're both educators, and we know how important it is that we meet all of our students' needs and the diversity of our students' needs out there. But I also know that we don't have all the questions ourselves, so it's an opportunity for all of us to learn and grow together and speak to the experts. It's hard to be a parent any time of the year, but it's been especially difficult during this pandemic. And there's been a lot of questions, and a lot of parents and a lot of school districts aren't sure really how to proceed in this moment. And your questions allow us to learn, to grow, and to do better, not just for your children, but for all the children out there. And so want to just thank you for joining us today, for taking this information and sharing it with other parents who are out there as well. And so tomorrow is National Special Education Day, and it commemorates the signing of the first federal special education law in 1975, where we celebrate our children, but also those who dedicate themselves to helping folks. And so want to thank everyone, including Disability Rights California, who's been doing this work for over 40 years to ensure all of our students get what they need and deserve out there. And so thank you again to the speaker's staff, to him for being an advocate and a champion for all of our students. And he talked about the conversation we had, but his reaction also speaks to who he was. And for him, this was important, it was imperative, and it was just the moral and right thing to do. And there was no hesitation on his behalf to get this going. And so I think we're lucky to have a partner and a neighbor and Speaker Rendon in this space. And so just thank you to the Rendon team for their dedication to all of our families across California.
Thank you so much, Assemblymember Garcia. That was really wonderful. Now we are going to have our presentation by Disability Rights California. We have an absolutely wonderful advocate and attorney here today with us. His name is Robert Borelli, and he's going to be giving us a presentation here. Just a few reminders, there is an email address, like the speaker mentioned, that you can email if you have any questions. If we don't get to your question later on in the segment, we will answer it via email. We'll figure out some way to get you some contact. So that email address again is assemblymember.rendon@assembly.ca.gov. So feel free to send any questions there. And then additionally, there's going to be a lot of good information shared, so you might want to get a pen and paper out. But we've also made these available on our website. They'll be live sometime tomorrow. So if you want to visit our websites, either Assemblymember Rendon's website or Assemblymember Garcia's website, we'll have this information on there sometime this week. For our team, it'll be under the district tab. So make sure to check that out. And so now we'd like to welcome up Robert Borelli for his great presentation.
Thanks, Avery. Let me get my PowerPoint shared real quick.
Great.
There you go. All right, well, thank you so much. Again, my name is Robert Borelli. I'm a supervising attorney at Disability Rights California. I am in our Los Angeles office. We also have regional offices across the state. I will be presenting, my colleague Gabriela Torres is giving a presentation tomorrow night in Spanish, so I encourage anyone to attend that as well. So a quick agenda of what I'm going to talk about today. First and foremost, I'm going to provide an overview of special education law. Just a quick primer for those of you who might not be as familiar. And then most of the training is going to be on changes to those laws during COVID-19. I did a training with the speaker's office back in April at the very beginning, and there weren't a lot of laws or guidance at the time. So you need to click on, oh, Andrew, which one am I displaying incorrectly?
If you could just click on display settings at the top of your screen and choose, I believe it's like swap displays or something.
Okay, and where is that display settings?
Should be at the very top of your screen.
Oh, I see it. Swap presenter.
Yep,
and
exactly.
all right.
Perfect. Sorry about that.
Okay. Sorry about that, guys. I've been in my home office for 8 months and I have not figured out this double monitor yet, so I apologize. Okay, so what I was saying is that in the past, almost 8 months now since I last presented with the speaker, there are a lot of guidance and laws now that really inform parents what their rights are during this time of distance learning. So I'm going to spend a lot of time on those. I also have resources for families, including resources from DRC and from other state agencies. And then we'll spend some time at the end with a Q&A discussion, answering the questions that you've all submitted. Okay, so first, Disability Rights California, for those who aren't familiar, we are the state's protection and advocacy agency. So we are designated by the federal government to protect and advocate for people with disabilities. And our mission as an organization is to advocate, educate, investigate, and litigate to advance the rights, dignity, equal opportunities, and choices for all people with disabilities. So I'm a part of Disability Rights California's youth practice group, and we mainly represent children in special ed matters, and the main law we deal with is the Individuals with Disabilities Education Act, or the IDA for short. The IDA is the federal law that provides eligible children with disabilities an individualized education program, or an IEP. And so children that have IEPs have the right to a free and appropriate public education in the least restrictive environment. And those may be two terms you're familiar with. So the IDA, when a child has an IEP, it provides them with special education instruction. So that's, your instruction you get from a special education teacher. And it also provides related services. So those are services, things like speech and language therapy, occupational therapy, physical therapy, counseling, any transportation your child gets through their IEP is also a related services. So those are those services that are separate from the actual instruction. The IDA also provides the parents a lot of procedural protection. So these are just some, but there's many, many protections you have. If you've ever been to an IEP meeting, the first thing they'll do is give you your notice of procedural safeguards. And it just explains your right of parent participation, your right to request an IEP meeting, your right to request assessments. Also included this are discipline protections. So you may have had a manifestation determination, which is an IEP meeting held to determine if a child's behavior that led to a discipline, a suspension or expulsion was related to their disability. So that all comes from the IDA as well. So here's a helpful chart that I like to include in presentations just to understand the kind of life cycle of the special ed process. So it starts with the referral for special education, and many different people can refer a child for an IEP assessment. A lot of times it's the parent where you request it in writing, but also a teacher, a doctor, an administrator can recommend that a child receive an assessment. So once there is that initial referral, that starts the process. From then, the school has 15 days to develop an assessment plan and present it to the parents. And that assessment plan lists all the areas the child will be assessed and who's going to do the assessment. And then when the parent signs that assessment plan, 60 days from that signature on the plan, the assessment should be done and the IEP team should meet for an initial IEP meeting to determine if the child's eligible. If the parent consents to the IEP, then the district has to implement it immediately. And from there, the IEP team has to meet at least once a year for the annual review, but parents also have the right to request an IEP meeting at any time. And the district has to hold that meeting within 30 days. And then there's something called a triennial reassessment, which is when the child is reassessed. And that has to happen at least every 3 years. And just a note with these timelines, the days don't apply during breaks that are, more than 5 days. So, 60 days, if there's a summer break, the 60 days is paused. Same with, winter break and those longer breaks. So keep that in mind. Okay, so now we're going to talk about the IDA during this period of distance learning related to the COVID-19 school closures. So what is really clear at this point is that the IDA is not waived, meaning Congress has not told the states and the school districts that this law, is paused or, not in effect. The districts still have to follow the IDA, and that means providing a child a FAPE, that right to a free and appropriate public education. But what the guidance has said from the federal government and the state government, the State Department of Education, is that yes, children have to have a FAPE, but how schools deliver the services may be a little different, just to ensure the health and safety of students and their teachers. So there is that element of flexibility. And so what that means is, in delivering the special education and related services, they may have to do distance learning, teletherapy, anyone who's had their children be in front of Zoom and take classes. Another thing is small cohort classrooms, which we'll talk about later, where some districts have allowed their schools to reopen for small groups of students. And sometimes, as we'll discuss, it may be appropriate for a school district to provide services in the home, especially if that's necessary to maintain a child's physical health or mental health and safety. Okay, so the main law. So this is a law. This is not a guidance document or recommendation. There was a law enacted in June of 2020 over the summer. It's called Senate Bill 98. And it was a massive budget bill that had a million things in it, but it did have several provisions that related to IEPs. So what this law said is that when a school is closed for an emergency, which it defines as 10 or more days, so obviously the COVID pandemic applies, then the district must update IEPs to describe how services will be delivered during that emergency. And it lists what types of services they're talking about. So the IEP must be updated to explain how the school is going to provide special education instruction and those related services, how it's going to provide supplemental aids and services, which are things that really help the child be in the least restricted environment. For example, some districts list one-to-one aids as supplemental aids and services instead of related services. So it all depends. Another thing the IEP has to include is transition services. So those are for children who are transitioning to adulthood. Those may be things like, career training, college awareness, things like that. And also it has to describe how they're going to provide extended school year services, which is just the fancy term for the summer services. So the question then is, okay, so we're closed for an emergency. When does the school have to have this emergency IEP plan in place? So the law says it has to be in place by the student's next annual IEP. So if you are a parent whose child's annual IEP is not coming up for a while, you absolutely can request your own IEP meeting to implement this emergency plan. And my hope is that most districts have already called them on their own since we're in December now. And just, I've called it an emergency plan, but some districts call them distance learning plans. I've seen districts call them emergency contingency plans. They're all the same thing. This is what this law encompasses. So Senate Bill 98 was a law, and I'm going to talk a little bit about guidance that has come out. And what guidance is, in law, we call it authoritative, meaning that it carries a lot of weight. It's not the letter of the law. It's not they have to do it. This is really the state telling districts how they view the law right now during this period of school closures. So back in April, the CDE, which is the California Department of Education, put out really substantive guidance about how schools have to implement IEPs during this time. And one of the things they said is, yes, school districts are allowed to provide services in the home. It doesn't say they have to, it says clearly that they are allowed to. And it says, especially, when should they do it? They should consider it in exceptional circumstances, they called it, which they define as situations where in-home support is necessary to maintain a student's health or safety during distance learning. And then they clarified that that person coming into the home, they're considered essential workers. So they said people like social workers, speech language pathologists, occupational therapists, physical therapists, nurses, behavioral healthcare workers, which are people who maybe are providing wraparound services and other educationally related mental health services to your child, and family care or respite providers. These people under the governor's executive orders are considered essential, so they're allowed to work during this time. So that was really important. Again, that came out in April, so it's not new, and we've seen children who maybe because of their disability just cannot safely access their distance learning. They can't safely access Zoom. I mean, that would be an appropriate situation where the parent could ask for in-home support. And then more recently, the CDE put out new guidance in the end of September, which I have links to everything, and of course we'll provide that afterwards as well. And it also said that schools may conduct assessments in person as long as it's done in compliance with public health guidance. They also may conduct these tests virtually, or they can do kind of augment their testing to, rely on data if they can't get in to actually test someone. And it is difficult. A lot of tests rely on observations in the classroom, and Zoom is just not the same. So it's really, you got to take it on a case-by-case basis, but it is clear that the state is allowing special ed assessments to be done in person. Okay, so I mentioned this before. This was, we called the cohort guidance, but back in September and October, the Department of Public Health put out guidance. This is when, you know, things were opening up a little bit, that, you know, schools could, if they want to, allow small group in-person services back in school, but it's very controlled. And their guidance talked about, okay, it can't be more than 14 students. There has to be 2 adults. There can be no mixing because they didn't want to, you know, create any risk to health, with the exception of one-to-one specialists. So, you know, a speech language pathologist could serve more than 1 student. The guidance made clear that everyone has to follow proper safety protocols. That includes social distancing, face coverings, cleaning the classroom. And they made clear it's not dependent on county health orders, which means that the state was allowing districts to do this independent of their counties. But what is clear, is I want to make clear, is that this allows districts to do it. They're not required to offer this type of cohort. It's more of an opt-in. In my experience, you know, here in LA, I haven't seen many opt-in at all. But this is something to keep in mind. And I have a link to the guidance there, which I'm sure we'll be updating as they go. But this is something to keep in mind you can bring to your district if you feel that, you know, a cohort would be more appropriate. Okay, so here's some tips for parents. These are very general tips, you know, how to handle IEP advocacy during this really difficult time. We recommend put your service or assessment requests in writing. Always put everything in writing, you know, instead of verbally asking. And once you request it in writing, you know, make sure the school acknowledges receipt, and then that triggers the school district's responsibility to provide you with a prior written notice, or PWN. And that is a legally required letter or notice that explains why it has accepted or rejected your request. Anytime the district proposes to do something or not to do something, they have to provide this document. And it's really important because it helps you understand their reasoning and whether you have grounds maybe for a complaint or something. But again, please make sure everything is in writing, especially at this time. Second, we recommend that families keep data and records. Keep a service log of any maybe services that are missed. We've been recommending this from the beginning because it may be helpful down the road for compensatory education, which is sometimes if a district fails to implement an IEP or denies a student's right, the child may be entitled to compensatory education to make up for those lost services. So it's important for you to keep a log so you know if anything has been missed. Always keep things like work samples and things like that to chart your child's progress or lack thereof. You know, keep tabs on how they're doing. So again, you can either request compensatory education or changes to the IEP going forward if you have evidence of regression. You may also have IEP meetings at this time, again, maybe to create a distance learning plan, maybe to tweak that distance learning plan. After the meeting, and when the district provides the IEP and the notes, read the IEP really carefully, read the notes really carefully, make sure that it's accurate. And if there is something that's wrong or something missing, ask them to make changes. You can submit a letter that they can attach to the IEP. Always ask them to attach it to the IEP, explaining what you don't agree with the notes, you know, what you want them to add. That's always an option and really important. The second bullet point here is limited consent, which means if the district offers, you know, 3 things and you agree to 2, but not the last one, you can consent to those first 2 things, and the district has to implement them. And then the other one, there's other options with that, but you can continue to negotiate, or there's, you know, dispute resolution, but The key is if there are services that you like and you want them implemented, you can give partial consent and they have to start immediately. Okay, the next advocacy tip is complaints. I'm not getting too in depth on complaints here because we can do an entire training on complaints. But just know that you do have complaint options. The three main ones that we deal with for students with disabilities who are elementary and high school age is a due process complaint with the Office of Administrative Hearings. This is the most formal type of complaint, and it's appropriate complaint when you are in a disagreement with the district over the IEP itself, whether this IEP is appropriate, whether this placement is too restrictive. That is when you would pursue a due process complaint. And once you file that complaint, we recommend parents have legal counsel for this because it is a mini trial. It's an administrative hearing. There is the taking of evidence. There's the testimony of witnesses. It is a lot for parents to handle. So we do recommend that you get counsel for something like that. The second type of complaint, we call them compliance complaints. You file those with the California Department of Education. And a compliance complaint, it's supposed to be more parent friendly. There is a form on the CDE's website that you can fill out and submit. It's for complaints that are more procedural, more straightforward. You get an hour of speech a week in your IEP, but the district is not providing it. That's a clear-cut violation. That would be more appropriate for a compliance complaint than due process, because you're not disagreeing over what should be in the IEP. You agree with the IEP, they're just not implementing it. And that third type of complaint is a discrimination complaint with the it's the U.S. Department of Education's Office for Civil Rights. This is not for an IEP violation per se, it's more for a discrimination complaint where there's discrimination on the basis of disability. So your child is not allowed to participate in a program because they have a disability. Things like that. The two main laws they implement, it's not the IDA, it's the Americans with Disabilities Act, and another law called Section 504 of the Rehabilitation Act, which prohibits disability discrimination by recipients of federal funding. So those complaints, there is also a form on OCR's website. And just keep in mind, though, that the statute of limitations with that is 6 months, so it's a pretty quick turnaround. And for all of these complaints, I highly recommend that you review Disability Rights California's SIR manual, which is kind of just a guide, a massive special education guide. And chapter 6 in that manual is about complaints. And we have a ton of information on the different types of complaints that are available. All right, so now I want to talk about masks, which is one of the main calls that we're getting at this time. So, if your school is reopening, the question is, what if my child can't wear a mask in school? And again, those two laws I mentioned, Title II of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, require schools to provide reasonable accommodations. So a reasonable accommodation is a bending of the rule, right? So if the school is saying you have to wear a mask to school, a reasonable accommodation could be a bending of that. Does that mean that your child has the right to not wear a mask? No. It depends on what is reasonable, and what is reasonable depends on the situation. So we recommend that if your child cannot wear a mask and the school is requiring it, that you ask the school for reasonable accommodation. And again, because it depends, work with the school to find an alternative that works. Maybe a face shield instead of a mask. There has to be what's called an interactive process between you and the school to figure out what is going to work where my child can go to school and still be safe and abide by the safety of everyone else. So again, it doesn't mean your child has a right to go to school without a mask. It depends, and it turns on what is reasonable. And we also have a guide on our website that just went up on masks in school, which we'll link to later. Okay, so here's a summary of resources, things that I've mentioned, and we're gonna, during the Q&A, I'll come back to this. So And these are all on our website. We have a COVID website, which links to all the education materials. But the main ones I've linked here are the California Department of Education Special Ed Guidance, which is a running tally of all, that link right there has all the guidance that they've issued since COVID hit in March. And it's really helpful. I like that they put it all on one site, where before we had to kind of fish around for it. And that's where the guidance is about, in-home services, in-person assessments, things like that. That is all there. This next one, DRC COVID Special Education page and form letters. This is our hub where we've been putting everything. It has form letters on how to request IEP services, IEP meetings, assessments, limited consent forms, which is that limited consent I talked about, where you like parts of the IEP and parts you don't. We have a sample service log where you can kind of log any services your child has missed. We also summarize all the federal and state guidance to try to put it in plain language for parents. The next one is our SIR manual, which we have in English and Spanish, and I believe a few other languages. There's a toggle button at the top. But this manual has been around for decades. We updated it last year. SIR stands for Special Education Rights and Responsibilities Manual. There are dozens of chapters on every issue you could ever think of. It's a great place to start if you're new to special education, or even if you're just trying to brush up. And I mentioned chapter 6 has complaints, so that would be a good place to start if you're interested in complaints. And then that last link is the DRC face mask publication, which we've recently updated to be more specific to schools. So with that, we're going to move to the Q&A portion. Avery, I'm going to stop my screen share.
Perfect. Go ahead.
Yeah, and I'll put the resources back up later.
Okay, great. And then one other question that I had actually, Robert, and you might have already mentioned it, but that was just a lot of good information. But is there a number that people can call for DRC if they want to do an intake or just kind of ask about their personal case?
There is. I apologize. That is on the handout I gave you. I did not put it on the PowerPoint. The number.
No problem.
We have the number and we have the TTY as well. Let me pull this up. Yeah, so we have an intake line, which is staffed by our intake advocates from 9 to 4 p.m. Monday through Friday. And that number is 1-800-776-5746.
Okay, great. And I'll mention it again at the end of the call, but thank you for providing that. I appreciate it. Okay, so whenever you're ready, we'll start the question portion here. So several of you have written in and sent questions. And so like I said, if we don't get to your question, we'll make sure to try to address it through email. But we did get some repeats, so we tried to pick the most popular questions. So Robert, are you ready?
I'm ready. Hit me.
Okay, great. So do you want to turn on your camera?
Sure.
That would be great. So that I'm not the only one here. Okay. So the first question is, what are some options for parents to get proper services for their child with dyslexia if their child's school has no teacher trained in structured literacy and no legitimate structured literacy program?
Okay, great question. So I have two answers. The first is, if you're looking for change on a systemic level and you're trying to get your school district to offer these proper services, put a group together, petition the school board, talk to the administration. And a great place to start is in 2017, the CDE put out a guide, a dyslexia guide. There was a law passed that required them to do that. And it has really great information on how to build a structured literacy program. And structured literacy just means addressing all parts of literacy, the auditory part of reading, the visual part. And the CDE's guidance, it's not a law. Again, it's just guidance, but it's a really helpful tool for you to bring to your district and say, like, this is what the state's recommending. It's there. And then my second part of the answer is on an individual level. The standard, again, is FAPE, but free appropriate public education. So if you have an assessment saying that this type of structured literacy program is appropriate for your child, I mean, the district has to provide it. Of course, you've got to get that assessment first. So, you know, when your child's getting assessed by the district, ask them to, don't be afraid, ask them to look at dyslexia, ask them to look for specific learning disability. There are particular assessments that are really appropriate for that, that they should look into. And if you don't agree with their assessment, you can always ask for what's called an independent educational evaluation. So, and these are all really complicated terms, but our website has all this information, and also feel free to call our intake line and we can provide more specific information.
No, that was great. Thank you, Robert. Okay, so the next question is, should school districts still be holding our annual IEP in a timely manner during the pandemic?
So the answer to that is yes. The IDA has not been waived. The timelines are still in place, including the obligation to hold an annual IEP. So there should be no reason why they can't do it in a timely manner.
Okay, great. And then what is a timely manner?
I mean, it depends. If it's an annual IEP, they have to hold it annually, you know,
Right.
no greater than a year. If you request an IEP meeting, they have to hold it within 30 days. So those are still in place. Those have not been waived.
Okay, thank you.
Mm-hmm.
Next question. Are schools required to provide special education aids to students, virtually or otherwise, if my child's IEP requires it?
Yeah, so the answer to this is it depends. It depends. The school district still has to provide an appropriate education. If an aid is necessary for that, then yes, they would have to provide it. Virtually or otherwise. If you want the aid in the home, I would point you to that CDE guidance that again says that schools are allowed to do it in exceptional circumstances when there's a threat to the child's health or safety. But it's not a yes or no answer. It depends on what's appropriate for your child. And if you feel you need it for an appropriate education, do not hesitate to put it in writing, especially if the IEP calls for it now.
Okay, great. Thank you. And this next question you touched on, but I think it bears repeating. So this person asked, how can I lodge a complaint against my child's school or school district if they are not providing my child's IEP services?
In that situation, I would recommend a compliance complaint with the California Department of Education. So with special education, you have the right to file a complaint with the state. You don't have to file with your school district first. So I would recommend that. For more information on those complaints, again, our SIR manual, Chapter 6, and also the California Department of Education's website on compliance complaints is pretty good. And it has a form that you can fill out to file the complaint. And they accept complaints by mail, by fax, by email. So there's a lot of options for parents.
That's great. Thank you so much, Robert. Okay, another question is, are school districts required to have plans for students with disabilities to return to school?
Right. And I saw this question. I wasn't sure if that meant return in person or just kind of return to school in general. But for schooling in general, I mean, there's those distance learning plans they now have to have under Senate Bill 98. For returning to school itself in person, if that's what the questioner meant, I don't think there's any requirements, but I would, work with the IEP team to make sure that if you are returning to school, that your IEP will be implemented immediately, especially if your distance learning plan is a little different than your regular IEP. I mean, your regular IEP should go back into effect. So I think that would be done through the IEP team.
Okay, great. Next, what can I do if my student has been suspended, but their IEP services are not being met? I thought this was illegal, but the school has done this.
Right. So this question, if your child's not receiving services while they're suspended, I mean, that's different than if you feel they're being suspended because their IEP services are not being met. And so generally here, I mentioned some procedural safeguards. if your child is suspended for 10 days or more, it triggers a requirement called the manifestation determination. And that requires the IEP team to meet to decide, okay, was the behavior that led to these suspensions, was it a manifestation of my child's disability? In other words, did their disability cause the behavior? And also they ask, was this caused by us not implementing the IEP? So I think that's maybe what the questioner is getting at. So that is clearly something that the IEP team would have to do for suspensions of 10 days or more. If your child hasn't been suspended that long, but you still feel like the IEP services are not being met, you could call an IEP meeting to discuss that. You also have complaint options if they're not implementing the IEP. But I would try to address it before that 10th suspension day, because that is a lot. You want to kind of make sure services are implemented if things get to that point.
Definitely. Thank you, Robert. Okay, the next question is, if a school district promises services for my student with a disability over email, but does not deliver them later or follow up, what can I do?
Sure, well, I would recommend this person, anytime the district offers services via email, call an IEP meeting and get those services in the IEP. The IEP is a contract. The parent has to consent to the services that are provided. So the email just doesn't carry the same force of law. I mean, it is important that they offer that, but I would formally convene to add that to the IEP, or you can do it through an IEP amendment, which is something where districts are allowed to change an IEP without a meeting, as long as the parent is okay with that. So they would send you the IEP via email or by mail, and you could consent that way. But you got to consent to it. You got to figure out a way to do that. And email alone is not enough.
Thank you, Robert. Okay. This question says, the pandemic has complicated services in so many different regards, but are you aware of some good examples that you can share from other districts that could perhaps be implemented in another?
That's a good question. Things that the districts that I've seen do things well are the ones being really flexible with these distance learning plans to create really individualized creative plans for children. Because, schooling via Zoom may work for some kids really, really well. Maybe, they have anxiety about being in school and they're relieved to do it by Zoom. Other kids, Zoom does not work at all. And this is just a really important time for the IEP team to come together. And the districts that I think do it well are the ones who are understanding and are flexible, are willing to maybe provide services in the home for children with more significant disabilities, who are willing to do assessments in person with proper PPE and social distancing and things like that. The districts who are issuing blanket denial, saying like, as a matter of policy, we don't do X, we don't do Y, those are the ones that really concern me. So I would just encourage flexibility from districts at this time, because it's really hard for families.
Yeah. Okay, thank you. That was helpful. What are options available for students who need one-on-one aids?
So for the families that have aids in their IEP already, that, if your child needs that to access their distance learning, the district should be providing, whether it's a virtual aid, or again, districts can provide aids in the home in those exceptional circumstances when there's a physical health or mental health issue. So those are options. You can request that in writing, cite the guidance that we've provided here. If you feel your child needs an aid and doesn't have one, again, request it in writing. Some districts do assessments to determine if a child needs an aid. Others, could do record reviews or whatever it is, but it is a service. At the end of the day, an aid is a service. So if you want it, you have to put your request in writing, and that triggers that obligation to provide the prior written notice explaining why or why not the district is going to do it.
Okay, great. Thank you so much. And then I'm going to jump around a little bit here. Are special education aids allowed to be used by schools for purposes other than as aids to our children with disabilities?
That is a really great question. This one made me laugh because I worked as a special ed aide after college, and back east. This is not California. Any administrators on the line, this is not about you. They made all the aides do other things that were not related to school, and it was a huge problem with our union. So this one made me laugh. But I mean, I'm not really sure what the question's asking. What are they doing? If to me, it depends on, is what the aide is being asked to do violate the student's IEP? So if a child has a one-to-one aide for the full day and the district's asking that aide to do something else, whether it's cafeteria duty, bus duty, and it's taking that child or the aide away from the child and there's no replacement, then that's a concern. So I would tie it down to the IEP. I mean, what aides are allowed to do, I think would depend district by district.
Okay, thank you. So another question. The service delivery system for students with special needs often includes teachers, specialists, aides, and of course, parents. Since the parent piece has increased dramatically due to students being at home, what kind of resources exist to help build parental skills at home? This is a great question.
That is a really great question. I mean, first I would say that in your area, there may be, there are parent advocacy groups that provide parent training. They're called family resource centers, especially, I believe family resource centers may be funded by the Land Term Act, so it's more geared toward regional center consumers, but they hold parent, social groups and trainings, things like that. There are also parent training information centers, which are funded by the federal government, and they provide special ed technical assistance to parents. So I would check your community. You could also call us. We can refer you to them. In terms of actual services the school can provide, there's a type of related services for children with more significant mental health needs. Some districts call them educationally related mental health services, or ERMs. Some call them educationally related intensive counseling services, or ERICs. It really depends. But within those are a number of different mental health services, including, wraparound services, which they're called wraparound because they wrap around the whole family. There are parent counseling as a service in that, so as a type of IEP service. So those are available for families who are dealing with, children with more significant mental health and behavioral disabilities. So that's something I would look into as well. But that's a really great question.
Yeah, and I also would like to point out as well that I know that Long Beach Forward is hosting a parent training for IEPs. And I know that the State Council on Developmental Disabilities does a lot of trainings as well. And of course, DRC does too. So you want to look out for those parent trainings because they're really great. And they're also obviously modified to the pandemic as well. So those are good places to look, DRC, the State Council on Developmental Disabilities, and Long Beach Forward, who in this case is partnering on one in January.
Right. State Council, that's a good one. Yeah.
And then this is the last question we have for tonight, and then I will close things out. So if/when an employee who helps service special needs students feels that the district is blocking attempts at providing FAPE for a student, is there a reporting mechanism for the employee that they can utilize that helps students get what they need without the employee's job being jeopardized?
Right. So this one's difficult. Of course, I'm a former educator, so I understand with unions, your union might have an ombudsman or whoever, and that's always an option. But as a special education lawyer, what I can tell you is that I have dealt with this, and I've had employees come to me before. One option is actually the compliance complaint, because what's interesting about the compliance complaint to the California Department of Ed is you don't have to be a student or the parent of a student to file. Really, anyone can file. I file them as the complainant myself all the time. It could be an organization, it could be a school district employee, really anyone, as long as you are alleging a violation. So in the past, I have helped employees file compliance complaints for things like a special ed teacher's caseload was exceeded the limits set by law, and she was really concerned. So I helped her do this and to work with the California Department of Education in a way that maintains confidentiality to protect the person's job. So it is sensitive, but know that that is an option. Whereas with other types of complaints like due process complaint, you have to be a parent or student. You have to be the rights holder for that, whether it's a CASA, legal guardian, whatever. You can't be an employee filing a student, whereas compliance complaints are much broader.
Okay. Well, thank you so much, Robert. I do want to give another opportunity to write down the Disability Rights California intake line. So I have it here. I'll read it out really quick. It's 1-800-776-5746. And that's also available on their website. I think that's a really good resource for anyone who maybe didn't get their questions answered or didn't ask a question because they thought it was too specific. And we also didn't want to reveal specific cases on the live stream here today. So that's a really good resource. Additionally, if you emailed us and you didn't get your question answered here tonight, please continue to email us. Obviously, I can share that with Robert. And if it's not something that maybe Robert can help with, we can get you a different service as well. And even if you have a question now and you didn't ask it before, you can still send it. So I'll repeat the email. It's assemblymember.rendon@assembly.ca.gov. So thank you guys so much again for calling tonight. If maybe you don't have access to a computer and you have questions or follow-up or even comments about tonight, ways to make it more accessible, you can contact our office, Assemblymember Rendon's office, at 562-529-3250, or Assemblymember Garcia's office at 562-861-5803. And those numbers are available online too. And then the resources we discussed tonight, if maybe there was links that you couldn't write down or it was too hard, it was going too fast, all the information is going to be posted on Assemblymember Rendon's website. So you can go check that out. It should be under the district tab and it should go live sometime tomorrow. So if you can't find that for some reason, feel free to call our offices, email us, anything we can do, we'll get you that information. So again, thank you so much, Robert, for coming tonight, and thank you all for joining us. It's been wonderful to work with you. All right, goodbye, everyone.